Before we begin, a quick and important disclaimer. This video discusses complex financial and legal concepts regarding retirement accounts and matrimonial law in the United States. The information provided here is strictly for educational and entertainment purposes and does not constitute professional financial, legal, or tax advice. Divorce laws and 401k regulations vary significantly by state and individual circumstances. You should always conduct your own due diligence and consult with a qualified attorney or a certified financial planner before making any decisions regarding your assets. Imagine working for 35 years, diligently contributing to your 401k, bypassing vacations and new cars to ensure a comfortable sunset to your life, only to realize that a single signature on a divorce decree could instantly reallocate 50% of that balance to someone else. In the United States, we are currently witnessing a massive shift in how wealth is perceived and partitioned. For decades, the primary battleground in a divorce was the family home. But as the American economy shifted from pensions to defined contribution plans, the 401k has become the largest liquid asset for millions of households. We are entering the era of the 401k divorce, a cultural evolution where the math of retirement is colliding head-on with the emotional reality of marital dissolution. Most people don't realize that their retirement account isn't just a personal piggy bank. In the eyes of the law, it is often a marital asset that began accruing a shared interest the moment they said "I do." If you don't understand the mechanics of the Qualified Domestic Relations Order, or QDRO, you aren't just losing a partner. You are potentially losing your ability to ever retire. Today, we are performing a deep dive masterclass into the evolution of American retirement and the legal frameworks that govern its division. By the end of this video, you will understand the historical trends that led us here, the precise step-by-step mechanics of how retirement assets are valued during a split, and the potential outcomes of common legal strategies used to protect or partition these funds. We are solving the mystery of the invisible asset, ensuring you have the knowledge to navigate the modern landscape of American domestic and financial life. To understand where we are, we have to look at the historical transition from the defined benefit era to the 401k era. Prior to the late 1970s, most American workers relied on pensions. These were employer-funded plans that paid out a set amount for life. When couples divorced in 1960, the pension was often ignored because it wasn't a pot of money you could see. It was a future promise. However, the introduction of the Revenue Act of 1978 changed everything. This created the 401k, shifting the responsibility of saving from the employer to the employee. As these accounts grew from zero to trillions of dollars in aggregate value, they became the crown jewel of the marital estate. This cultural evolution has created a new set of stakes. Unlike a house, which has a tangible market value you can see on a website, a 401k is a moving target. It fluctuates with the S&P 500, it carries deferred tax liabilities, and it is governed by federal laws like ERISA, the Employee Retirement Income Security Act of 1974. When a couple in the U.S. decides to part ways, they aren't just dividing cash. They are dividing a tax-advantaged vehicle. This is where the complexity begins. Let's look at a case study involving a hypothetical couple, Sarah and Michael. Michael has been a software engineer for 20 years. When he married Sarah 10 years ago, his 401k was worth $100,000. Today it is worth $600,000. In many U.S. jurisdictions, the court doesn't just look at the $600,000 and split it in half. They look at the appreciation during the marriage. This is known as the marital portion. The $100,000 he had before the wedding might be considered separate property, but the $500,000 in growth and new contributions? That is often considered community or marital property. But here is where the math gets brutal. If Michael simply withdraws $250,000 to pay Sarah her share, he is hit with immediate federal income tax and, if he is under age 59 and a half, a 10% early withdrawal penalty. This is why the QDRO was invented. A Qualified Domestic Relations Order is a legal instruction to the plan administrator that allows for the tax-free transfer of funds from one spouse's retirement account to an account for the other spouse. It is the only way to move this money without the IRS taking a massive bite out of the principal immediately. The cultural evolution of the 401k divorce also touches on the concept of the silver divorce. We are seeing a historical trend where couples over the age of 50 are divorcing at twice the rate they were in the 1990s. For these individuals, the 401k is not just a line item. It is their entire survival strategy. When you split a 401k at age 30, you have decades to recover the losses through compound interest. When you split it at age 62, the math of recovery becomes nearly impossible. This has led to a new level of financial litigation where forensic accountants are brought in to trace every contribution made over a 30-year marriage. Furthermore, we have to address the psychological shift. In the past, the primary earner often felt a sense of sole ownership over their retirement account because their name was on the statement. However, U.S. family law increasingly views marriage as an economic partnership. If one spouse stayed home to raise children while the other contributed to a 401k, the law recognizes that the stay-at-home spouse provided the support system that allowed those contributions to happen. Therefore, the retirement account is viewed as a joint achievement. This brings us to the importance of valuation dates. In a volatile market, the day the account is valued can change the outcome by tens of thousands of dollars. If a divorce is filed during a market peak, but the funds aren't transferred until a market crash, who bears the loss? These are the granular details that define the modern American divorce experience. We also see the rise of offsetting assets. In many cases, one spouse may choose to keep the entire 401k while giving up their interest in the family home. This requires a complex calculation known as tax affecting. Since $500,000 in a 401k is eventually taxable and $500,000 in home equity is often not, they are not actually worth the same amount of money. As we move through this series, we will examine the specific federal statutes that protect these assets and the loopholes that often lead to unexpected outcomes. We will look at how 403b plans for teachers and 457 plans for government workers differ from the standard 401k. The cultural evolution of the U.S. 401k divorce is a story of how we moved from communal security to individual risk, and how that risk is finally accounted for when a marriage ends. This is the new reality of the American dream. A dream that is increasingly documented in spreadsheets and settled in family court. Understanding these mechanics is the only way to ensure that your financial future remains intact, regardless of your marital status. By examining the data and the historical trends, we can see that the 401k divorce is not just a legal event. It is a fundamental shift in the American social contract. To understand the magnitude of this shift in 2026, we have to look at the staggering concentration of wealth within these accounts. According to historical trends from the Federal Reserve and industry analysts, the total assets in 401k plans and IRAs have climbed to over $35 trillion. For many Americans, this isn't just money. It is their only shield against an uncertain economic future. Imagine a professional in Chicago named Robert. It is March 2026, and Robert is 54 years old. He has spent the last 30 years working in logistics, contributing 6% of his salary every month, capturing every bit of his employer's match, and seeing his balance grow to $850,000. In his mind, that number represents his ability to stop working at 65. But when Robert and his spouse decide to dissolve their marriage, that $850,000 is no longer a personal achievement. It becomes a line item on a balance sheet that is subject to the principles of equitable distribution or community property, depending on where they live. The first major hurdle in this cultural evolution is the distinction between these two legal frameworks. If you live in a community property state like California, Texas, or Arizona, the law generally views all assets acquired during the marriage as owned 50-50. If Robert started his 401k on his wedding day, the math is straightforward. $425,000 belongs to each party. However, if you live in an equitable distribution state like New York or Florida, the division isn't necessarily a clean split. The court looks at factors such as the length of the marriage, the age and health of each spouse, and the future earning potential of both parties. In an equitable distribution scenario, a judge might decide that one spouse deserves 60% of the 401k because the other spouse has a much higher salary and can replenish their savings faster. This creates a high-stakes negotiation where every contribution made prior to the marriage must be meticulously accounted for to ensure it is classified as separate property. Imagine the complexity of tracing those funds. Let's say Robert had $50,000 in his 401k before he got married. Over 20 years, that $50,000 grew due to market performance, but he also added another $400,000 in new contributions during the marriage, which also grew. The court has to determine what portion of the final $850,000 is a direct result of that original separate $50,000. This is not just a simple subtraction. It involves financial tracing where experts look at the rate of return on the separate portion versus the marital portion. This brings us to the concept of the coverture fraction or the Majoska's formula, which is a mathematical tool often used to determine the marital share of a retirement asset. It essentially divides the number of years the person participated in the plan during the marriage by the total number of years they participated in the plan. This fraction is then applied to the total value to find the marital portion. Now let's talk about the specific mechanics of the transfer, because this is where the most significant financial damage occurs if handled incorrectly. In 2026, the IRS remains incredibly vigilant about early withdrawals. If Robert were to simply write his spouse a check for her share of the 401k, he would have to withdraw that money from the account. Under current tax code, that withdrawal would be taxed as ordinary income at his highest marginal rate. If he is in the 24% tax bracket, nearly 1/4 of that money vanishes instantly. On top of that, if he is under the age of 59 and a half, he would face a 10% early withdrawal penalty. This is why the Qualified Domestic Relations Order, or QDRO, is the most important document in a 401k divorce. A QDRO is a specialized legal order that instructs the plan administrator, the company managing the 401k, to carve out a portion of the account and move it into a separate account for the non-employee spouse, often called the alternate payee. When this is done via a QDRO, the transfer is not considered a taxable event. The money stays in a tax-advantaged environment. The alternate payee can then choose to keep the money in the existing plan in their own name, if the plan allows it, or roll it over into their own IRA. This preservation of the tax-deferred status is the difference between a spouse receiving $200,000 in actual value versus $130,000 after taxes and penalties. However, there is a historical trend of QDROs being filed months or even years after the divorce is finalized. This is a massive risk. Imagine if Robert's 401k is valued at $850,000 on the day of the divorce, and the court awards his spouse 50%. If the QDRO isn't filed immediately and the market experiences a significant downturn, the account might drop to $600,000. If the wording of the divorce decree isn't precise, there may be a dispute over whether the spouse gets 50% of the original value or 50% of the current, lower value. Conversely, if the account grows, the employee spouse might feel they are unfairly losing out on the growth that happened after the marriage ended. There is also the factor of outstanding 401k loans. In the United States, it is common for workers to take loans against their retirement for home improvements or debt consolidation. In 2026, many households have leveraged these accounts. When a divorce occurs, an outstanding loan is considered a reduction in the account's value. If Robert has a $50,000 loan against his 401k, the court must decide who is responsible for that debt. If it was used for a marital purpose like fixing the roof of the family home, the debt might be shared. If it was used for a personal expense, the spouse with the account might be forced to pay it back in full before the division occurs, or the total value will be adjusted downward. We also see a cultural shift in how younger generations approach this. Millennials and Gen Z are increasingly using prenuptial and postnuptial agreements to ring-fence their 401k accounts. They are witnessing the financial fallout of their parents' generation, and are choosing to define their retirement as separate property from day one. Case studies suggest that having a clear, legally binding document that stipulates how retirement growth will be handled can significantly reduce the duration and cost of a divorce. Without such an agreement, the 401k becomes the centerpiece of a legal tug-of-war that can cost tens of thousands of dollars in legal fees, further eroding the very asset they are fighting over. But what happens when the 401k isn't the only retirement vehicle? What if there are multiple accounts, some with different tax statuses like a Roth 401k? In a Roth 401k, the money has already been taxed. This makes it significantly more valuable than a traditional 401k of the same dollar amount. If Robert has $200,000 in a traditional 401k and $200,000 in a Roth 401k, he does not have $400,000 in equal assets. One is pre-tax and one is post-tax. If his spouse takes the Roth and he takes the traditional, he is effectively receiving about 30% less in actual spending power once he reaches retirement. This level of detail is why the 401k divorce has become a masterclass in financial literacy. It forces individuals to understand tax brackets, market volatility, and the long-term impact of compound interest. It is a moment where the personal and the systemic collide, requiring a level of precision that most people are unprepared for. As we continue, we have to look closer at what happens when the QDRO is actually executed. There are hidden fees, specific plan rules, and potential traps that can delay the transfer of funds for years. And more importantly, There is a specific provision in the law that allows a spouse to access these funds before age 59 and a half without a penalty, but only during a divorce. This one exception can be a lifeline or a disaster, depending on how it is used. Why would the IRS allow you to avoid the 10% penalty just because you are getting divorced? And how can you use this specific rule to pay off marital debt without destroying your future? In the next part, we will dive into the technicalities of the Section 72(t) exceptions and the hidden cash-out option that many attorneys forget to tell their clients about. The intersection of IRS tax codes and domestic relations is often where the most significant financial leverage is found, yet it remains one of the most misunderstood areas of American law. As we sit here in 2026, the cost of living and the burden of marital debt have made liquidity a primary concern for divorcing couples. This brings us to a specific, high-stakes provision known as the Section 72(t)(2) exception. Under normal circumstances, the Internal Revenue Code is designed to be a one-way street until you reach retirement age. If you attempt to pull money out of a 401k before age 59 and a half, the government views it as an unauthorized raid on your future, slapping you with a 10% early withdrawal penalty on top of the standard income tax. However, the law provides a unique window of opportunity during a divorce that does not exist at any other time in a taxpayer's life. When a 401k is divided via a Qualified Domestic Relations Order, or QDRO, the person receiving the money, the alternate payee, has a choice that the original account holder does not. Imagine a character named Jennifer. It is 2026, and Jennifer is 42 years old. She is finalizing a divorce from her husband, who has a 401k valued at $500,000. As part of the settlement, Jennifer is awarded $200,000 of that account. Under the specific rules of a QDRO, Jennifer can choose to take a portion of that $200,000 as a direct cash distribution rather than rolling it all over into an IRA. Because this distribution is being made pursuant to a QDRO, the 10% early withdrawal penalty is waived. Let that sink in. If Jennifer were to take $50,000 from her own 401k at age 42, she would lose $5,000 immediately to the penalty. But because she is receiving this money from her ex-spouse's 401k through a QDRO, she avoids that $5,000 hit. She still owes federal and state income tax, as the money is treated as ordinary income, but the penalty is gone. This is a critical tool for many Americans in 2026 who are facing the immediate costs of setting up a new household, paying off joint credit card debt, or covering legal fees. It is a one-time liquidity event that can prevent a newly single person from spiraling into high-interest debt. However, the step-by-step execution of this is fraught with danger. A common mistake in these case studies involves the timing of the rollover. If Jennifer rolls the entire $200,000 into her own traditional IRA, and then decides a month later that she needs $10,000 for a security deposit on an apartment, she has lost the exception. Once the money touches an IRA, it is governed by IRA rules, not QDRO rules. The QDRO exception for the 10% penalty only applies to distributions taken directly from the 401k plan at the time the QDRO is processed. This requires the QDRO to be drafted with extreme precision, instructing the plan administrator to pay out X amount to the alternate payee and roll over the remainder to an IRA. If the paperwork is not exactly right, the plan administrator will default to the most conservative tax treatment, potentially costing the recipient thousands of dollars. This brings us to a deeper cultural evolution: the rise of the specialized QDRO attorney. In previous decades, a general family law attorney would handle everything from child custody to the division of the 401k. But in 2026, the complexity of ERISA law and the sheer variety of employer-sponsored plans have made this a risky proposition. There are now over 100,000 different 401k plan variations in the United States, each with its own summary plan description and specific rules for how they handle QDROs. Some plans allow for an immediate lump sum payout to the alternate payee, while others require the alternate payee to wait until the employee spouse reaches retirement age to begin receiving payments. Imagine if Jennifer's ex-spouse worked for a legacy manufacturing company with a highly restrictive 401k plan. She might sign a divorce decree thinking she is getting $200,000 today, only to find out from the plan administrator that the company does not allow segregated accounts for ex-spouses. She might be forced to wait 15 years to touch a single cent of that money. This creates a massive valuation problem. $200,000 today is not the same as $200,000 in 15 years. In the current 2026 economic environment, where inflation has historically impacted purchasing power, a delayed distribution can be a financial catastrophe. To navigate this, experts now use a step-by-step verification process before the divorce is even finalized. First, the attorney must obtain the Summary Plan Description, or SPD, from the employer's HR department. This document is the Bible for the retirement plan. It dictates whether the plan accepts QDROs, what the administrative fees are, which can range from $500 to $3,000 just to process the paperwork, and whether the alternate payee can take an immediate distribution. Second, the attorney should submit a draft QDRO to the plan administrator for pre-approval. Waiting until after the judge signs the order to see if the plan will accept it is a recipe for months of legal gridlock. Another layer of this evolution involves the tax affecting of the 401k. As we discussed earlier, not all dollars are created equal. Let's look at another case study, Mark and Sarah. Mark has a 401k worth $300,000, and the couple has $300,000 in home equity. They decide on a simple trade. Mark keeps the 401k, and Sarah keeps the house. On paper, it looks like a 50-50 split. However, in 2026, the tax implications make this a lopsided deal. Sarah's $300,000 in home equity is largely tax-free upon sale due to the primary residence exclusion. Mark's $300,000 in the 401k is a debt to the IRS. When he eventually withdraws that money in retirement, he will likely pay 25 to 30% in taxes. Mark hasn't kept $300,000. He has kept $210,000. In a professional deep dive masterclass, we have to talk about the tactical use of the 401k loan in this context. Suppose a couple is heading toward divorce and they have significant credit card debt. In some cases, they might choose to take a loan from the 401k to pay off the high-interest debt before filing. This effectively converts a high-interest unsecured debt into a low-interest secured debt owed to themselves. However, this is a high-risk move. If the spouse who took the loan loses their job or leaves the company during the divorce proceedings, the entire balance of the loan is often due immediately. If it isn't paid back, it's treated as a distribution, triggering taxes and penalties at the worst possible time. We are also seeing a historical trend where 401k plans are being used as a bargaining chip for alimony or spousal support. In 2026, rather than paying monthly alimony out of a paycheck, which is no longer tax-deductible for the payer under federal law, some individuals are offering a larger share of the 401k in exchange for a waiver of future support. This is the ultimate trade-off: current cash flow versus future security. It requires a sophisticated understanding of the time value of money. How much 401k principal equals 5 years of monthly support. This leads to an even more complex scenario involving the beneficiary designations. One of the most common and tragic errors in American divorce history is the failure to update beneficiary forms. Even if a divorce decree says the ex-spouse has no right to the 401k, if the participant dies and the beneficiary form still lists the ex-spouse, federal ERISA law often dictates that the money goes to the ex-spouse regardless of what the state-level divorce decree says. The Supreme Court has been very clear on this. The plan documents trump the divorce decree. But what if the 401k isn't just a collection of mutual funds? What if it contains company stock or even alternative assets? And what happens when the 401k belongs to a business owner who has been using it as a sophisticated tax shelter? In the next part, we're going to look at the dark side of retirement division, the tactics used to hide or undervalue these accounts, and the digital forensics being used in 2026 to track down every missing cent. As we move deeper into 2026, the complexity of the American financial landscape has made it increasingly difficult to maintain total transparency during a divorce. While most people view a 401k as a transparent, employer-managed account, the cultural evolution of high-net-worth splits has revealed a dark side of asset concealment and valuation manipulation. We are now seeing a rise in what forensic accountants call the gray zones of retirement savings. These are not necessarily illegal acts in every instance, but they represent a strategic attempt to minimize the marital pot before the court can take a measurement. In the United States, the 401k is often the first place people look, but in 2026, it is also the first place people learn to hide. Imagine a scenario involving a character named David. David is a senior executive at a mid-sized tech firm in Austin, Texas. He knows his marriage is ending 6 months before he actually files the paperwork. In that 6-month window, David has several levers he can pull to artificially deflate the apparent value of his 401k. One common historical trend is the strategic suspension of contributions. By stopping his 6% contribution and the associated employer match, David prevents the account from growing by another $20,000 or $30,000 before the valuation date. While this seems like a small move over a protracted legal battle, it can shift the needle significantly in his favor. But David might go further. In 2026, many high-tier 401k plans offer a brokerage window, often referred to as a self-directed option within the 401k. This allows the participant to move money out of standard mutual funds and into more volatile or illiquid assets. David could theoretically shift his balance into high-risk, speculative investments that he expects to dip temporarily in value. If the valuation of the marital estate happens during a controlled market dip within his specific portfolio, the amount he owes his spouse is based on that depressed number. This is a high-stakes game of financial chicken, but in a world where 401k balances regularly exceed 7 figures, the potential outcomes for the individual keeping the account are substantial. To counter this, the U.S. legal system has evolved to include digital forensics and exhaustive discovery phases. In 2026, a standard subpoena doesn't just ask for the current balance. It asks for a 5-year transaction history. Forensic accountants look for unusual patterns. They look for massive shifts in asset allocation right before a filing. They look for 401k loans that were taken out and immediately funneled into separate, private accounts or used to purchase assets that are harder to track, like physical gold or certain digital assets that might not be immediately visible on a standard bank statement. Let's look at a case study involving a small business owner named Marcus. Marcus has a solo 401k, a powerful tool for the self-employed in the United States. Because Marcus is both the employer and the employee, he has an incredible amount of control over the timing and size of contributions. During his divorce, Marcus might attempt to claim that his business had a terrible year, thus justifying a $0 contribution to his retirement. However, a forensic deep dive might reveal that the business actually had record profits, which he deferred into the following tax year to keep his 401k and his reported income artificially low. This is known as income smoothing or deferral, and in 2026, it is a primary target for matrimonial attorneys. The discovery process for a 401k in 2026 is a step-by-step hunt. It begins with the request for production of documents. A skilled legal team won't just ask for the 401k statement. They will ask for the plan document, the summary plan description, and the individual benefit statement. These documents reveal if there are hidden components, such as a non-qualified deferred compensation plan that sits alongside the 401k. These executive-level plans are often where the real wealth is hidden, as they aren't governed by the same strict reporting rules as a standard 401k. If an attorney only looks at the 401k, they might be missing millions of dollars in deferred bonuses that are set to vest just after the divorce is finalized. Then there is the issue of the valuation date itself. In many U.S. states, the date used to value the 401k is the date of filing. In others, it is the date of the actual trial. In a volatile 2026 economy, the difference between those two dates could be 6 months and a 20% swing in the stock market. Imagine if a spouse is awarded 50% of a 401k, worth $1 million on the date of filing. If the market crashes before the QDRO is executed and the account drops to $700,000, does the spouse still get $500,000? In many jurisdictions, the answer is yes, unless the original agreement specified that the spouse receives a percentage of the account at the time of transfer, rather than a fixed dollar amount. This single-word choice, percentage versus dollar amount, is the difference between financial stability and a legal nightmare. We must also consider the role of 401k loans as a weapon of attrition. In some cases, a spouse might intentionally max out a 401k loan to pay for their own legal fees, effectively using marital assets to fund a fight against the other spouse. Because the loan reduces the net value of the 401k, the spouse who isn't in control of the account sees their potential settlement shrinking in real time. The court then has to decide if that loan was a dissipation of marital assets. If the judge rules it was dissipation, they might credit that $50,000 loan back to the other spouse's column, but if the money is already spent on lawyers, the liquidity is gone. This brings us to the cultural evolution of the 401k as a tool for financial coercion. We are seeing more cases in 2026 where the primary earner uses the complexity of the 401k and the cost of a QDRO as a way to force a faster, less favorable settlement. They might offer a larger share of the furniture or the cars, assets that depreciate, in exchange for keeping the 401k intact. To the untrained eye, getting the house and the Tesla seems like a win. But when you factor in the long-term compound interest of a 7-figure 401k, the spouse who kept the retirement account usually ends up with 5 to 10 times the wealth a decade later. The forensics of 2026 also have to deal with the integration of international assets. With the rise of remote work, many Americans now have retirement interests in foreign companies or have rolled 401k funds into offshore vehicles. Tracking these requires international cooperation and specialized experts who understand how a U.S. QDRO interacts with foreign pension schemes. It is a world away from the simple 1980s divorce where you just split the house and the checking account. But even if you find all the money, and even if you have a perfect valuation, there is still one massive hurdle that can stop the entire process in its tracks. Most people assume that once a judge signs a paper, the money moves. That is a dangerous assumption. There is a silent gatekeeper in this process, the plan administrator. These are the corporate entities that actually hold the money, and they don't answer to the divorce judge. They answer to federal law. If your QDRO doesn't meet their specific, often arbitrary standards, they will reject it, and you will be back at square one, paying more legal fees while your assets sit in limbo. What are the specific secret phrases that plan administrators look for in a QDRO? And why are some of the biggest companies in America currently being sued for how they handle 401k divisions? In the next part, we're going into the belly of the beast, the administrative rejection loop, and the step-by-step blueprint to making your QDRO bulletproof on the first try. The moment a judge signs your divorce decree, you might feel a sense of relief, but in the world of 401k divisions, the judge is not the final boss. That title belongs to the plan administrator. In 2026, the administrative rejection loop has become a primary source of frustration for thousands of Americans. You have to understand that a 401k plan is governed by ERISA, a federal law that often supersedes state court orders. If your legal team drafts a qualified domestic relations order that conflicts with the specific technical requirements of the company's retirement plan, the plan administrator has the federal authority and the legal obligation to reject it. This isn't just a minor delay. A rejection can send you back to the drawing board for months, racking up thousands in additional legal fees while your assets remain frozen or worse, subject to market volatility you can no longer control. Imagine a character named Elena. It is 2026, and Elena has finally reached a settlement after an 18-month divorce battle. She is awarded $400,000 from her ex-husband's 401k at a major aerospace firm. Her attorney drafts the QDRO and sends it to the court. The judge signs it, and they mail it off to the plan's corporate headquarters. 3 weeks later, Elena receives a cold, formal letter stating that the QDRO has been deemed non-qualified. The reason? A tiny phrasing error regarding the definition of the valuation date or a failure to specify how the plan should handle investment earnings between the date of the order and the date of the actual distribution. To the plan administrator, Elena's court order is just a piece of paper until it perfectly aligns with their internal operations manual. This administrative rejection loop is a byproduct of the cultural evolution toward hyperspecialization. In the past, plan administrators were often small HR departments that were more flexible. In 2026, most major American corporations outsource their 401k management to massive third-party record keepers. These entities handle millions of accounts and use automated systems to vet QDROs. If the document doesn't contain the specific secret phrases required by that specific record keeper, the system flags it for rejection. For example, some plans require the document to explicitly state whether the alternate payee is entitled to a proportionate share of any dividends or interest accrued during the processing period. If the QDRO is silent on this, the administrator may reject it rather than making an assumption that could lead to a lawsuit from the participant's spouse. To make a QDRO bulletproof in 2026, you must follow a meticulous step-by-step blueprint that begins long before the divorce is final. Step 1 is the formal request for the model QDRO. Most large-scale 401k plans have a pre-approved template. Using the company's own template is the single most effective way to avoid the rejection loop. If you try to get creative or use a generic form from a state-level legal website, you are inviting a rejection. The model QDRO will contain the specific language the plan's legal department has already vetted. Step 2 is the pre-approval process, often called a draft review. In 2026, many sophisticated plan administrators offer a portal where your attorney can upload a draft of the QDRO before it is signed by the judge. This is a critical historical trend in modern divorce practice. By getting a preliminary approval, you ensure that once the judge signs the final version, the plan is already committed to accepting it. If the administrator identifies an issue during the draft phase, such as an incorrect plan name or an invalid social security number format, it can be fixed in minutes rather than months. Step 3 involves the specific treatment of gains and losses. This is where most QDROs fail. In a fluctuating market, the value of a 401k can change by 5% in a single week. Your QDRO must state with absolute clarity whether the amount being transferred is a flat dollar amount or a percentage of the account. If it is a percentage, does that percentage apply to the balance as of the date of the divorce, or the balance as of the date of the actual transfer? If it is a flat dollar amount, does that amount include investment earnings or losses that occur while the paperwork is being shuffled? In 2026, we see case studies where failing to specify this resulted in the alternate payee receiving $40,000, less than they expected because the market dipped during the 60-day processing window. We also have to discuss the administrative fees, which have become a point of contention in modern American divorces. In 2026, it is standard for a 401k plan to charge a fee for processing a QDRO, often ranging from $800 to $1,500. The QDRO must specify who pays this fee. Will it be deducted from the participant's remaining balance, taken out of the alternate payee's share, or split 50-50? If the QDRO is silent on the fee, the plan administrator may default to their own internal policy, which might not be what the parties intended. This is a granular detail, but in a deep dive masterclass, we recognize that these small oversight points are where the emotional stress of a divorce is amplified. There is also the historical trend of the separate interest versus the shared interest QDRO. This is a technical distinction that can fundamentally change your retirement. A separate interest QDRO actually carves out a piece of the account and gives the ex-spouse total control over it, as if it were their own account. They can choose their own investments and their own beneficiary. A shared interest QDRO, which is more common in older pension-style plans but still appears in some 401k structures, merely gives the ex-spouse a right to a portion of the payments when the participant spouse starts taking them. In 2026, the separate interest QDRO is the gold standard for 401k divisions because it provides the clean break that most couples desire. Imagine the risk of the participant spouse attempting to sabotage the process. While the QDRO is being drafted, the participant still has control over the account. They could theoretically change the investment allocations to something extremely conservative to prevent growth, or something extremely aggressive to trigger a loss. This is why a well-drafted QDRO should include a freeze request. Once the plan administrator receives notice of a pending QDRO, they can often place a temporary hold on the account, preventing loans or significant changes until the legal division is complete. This protective measure is a key evolution in safeguarding marital assets during the high-tension period of litigation. As we look at the broader cultural evolution, we see that the 401k is no longer just a retirement fund. It is a complex legal entity that requires its own specialized set of documents. The 2026 landscape is one where the paperwork is as important as the money itself. You can have $1 million in an account, but if you don't have a qualified order, that money is effectively behind an unbreakable glass wall. The administrative rejection loop is the primary reason why divorces in the U.S. often drag on for years after the couple has stopped living together. But what happens once the money finally moves? What if the ex-spouse doesn't want to leave the money in the 401k? What if they want to use it to buy a house or start a business? The tax implications of these decisions are the next major hurdle. Many people don't realize that how you move the money out of the 401k can trigger an IRS audit if not reported correctly on your 2026 tax return. And there is a specific, little-known strategy for the participant spouse to replenish their 401k much faster than the standard contribution limits allow after a divorce. How do you handle the taxes on a 401k distribution in a way that keeps the IRS away from your door? And what are the secret contribution catch-up rules that only apply in the wake of a legal separation? In the next part, we are going to break down the post-QDRO tax landscape and the strategies for rebuilding your wealth when you are starting from 50%. The moment the funds are officially segregated into a new account for the alternate payee, a new financial timeline begins. In 2026, the post-QDRO tax landscape is a minefield where a single misstep in reporting can result in an automated IRS notice, or worse, an unexpected tax bill that consumes your remaining liquidity. For the spouse receiving the funds, The primary question is whether to maintain the tax-deferred status or to access the cash immediately. As we have discussed, the QDRO allows for a one-time penalty-free withdrawal, but the tax reporting requirements are stringent. Imagine a character named Thomas. It is July 2026, and Thomas has just received $250,000 from his ex-wife's 401k following a 2-year legal battle. Thomas decides he needs $50,000 to pay off his divorce attorney and secure a down payment for a new townhouse. He instructs the plan administrator to pay him $50,000 in cash and roll the remaining $200,000 into a newly established traditional IRA. Thomas might assume that since the 10% penalty is waived under Section 72T, he is in the clear. However, the plan administrator is required by law to withhold 20% for federal income taxes on any direct distribution. This means Thomas only receives $40,000 in his bank account, while $10,000 is sent to the IRS as a withholding. This is where the math gets complicated. If Thomas is in a higher tax bracket, perhaps the 32% bracket due to his own professional income, that $10,000 withholding won't be enough. When he files his 2026 tax return in April 2027, he will owe the difference between the 20% withheld and his actual effective tax rate. This creates a ghost tax liability that many people fail to plan for. In this case study, Thomas might end up owing an additional $6,000 to the IRS months after the money has already been spent. Historical trends show that many newly divorced individuals fail to adjust their quarterly estimated payments or their W-4 withholdings to account for this one-time income spike, leading to significant underpayment penalties. For the spouse who provided the funds, the participant spouse, the challenge is entirely different. They are looking at an account that has been halved. In 2026, the psychological impact of seeing a retirement balance drop from $500,000 to $250,000 can lead to investment paralysis or, conversely, a dangerous urge to over-leverage in high-risk assets to catch up. However, the U.S. tax code provides certain mechanisms that can help in rebuilding. While there is no secret loophole to double your contribution limits just because of a divorce, the cultural evolution of the workplace has led to the proliferation of the mega backdoor Roth strategy in many high-end 401k plans. If the participant spouse's plan allows for after-tax contributions and in-service distributions, they may be able to contribute significantly more than the standard $23,000 limit, potentially up to $69,000 or more in total contributions including employer matches, depending on the 2026 limits set by the IRS. By maximizing these after-tax contributions and immediately converting them to a Roth 401k or Roth IRA, the participant can rebuild their tax-free wealth at an accelerated pace. This is a technical maneuver that requires the plan to have specific provisions, but for a high earner looking to recover from a 401k divorce, it is one of the few historical trends that offers a path toward rapid replenishment. We also have to consider the role of the catch-up contribution. In 2026, for those aged 50 and older, the IRS allows an additional $7,500 in contributions. Following a divorce, utilizing this becomes a mandatory strategy for those in the silver divorce category. Furthermore, the Secure Act 2.0 has introduced changes to how these catch-up contributions are handled for high earners, often requiring them to be made on a Roth basis. This means the participant is not only rebuilding their balance, but shifting the tax characteristics of their retirement to a more favorable, tax-free status for the future. Let's look at the reporting mechanics for the 2026 tax year. When the 401k is split, the plan administrator will issue a Form 1099-R. For the alternate payee, this form will have a specific code in Box 7, usually Code 2 or Code G. Code 2 indicates an early distribution that is an exception to the penalty, specifically for a QDRO. If Thomas, our character from earlier, receives a 1099-R with the wrong code, the IRS computers will automatically flag the $50,000 withdrawal and assess the $5,000 penalty. Thomas would then have to go through the arduous process of proving to the IRS that the distribution was part of a QDRO, which requires submitting the court order and the plan's acceptance letter. This is why keeping a meticulous paper trail of every document from the plan administrator is non-negotiable. Another layer of the post-divorce financial evolution is the reassessment of asset allocation. A married couple often invests as a unit. Maybe one spouse's 401k is heavily in aggressive stocks while the other's is in conservative bonds, creating a balanced overall portfolio. Once the divorce is finalized, that balance is shattered. Each person is now an individual economic unit. If Thomas's ex-wife kept the bond-heavy portion and Thomas was left with the stock-heavy portion just as the market enters a 2026 correction, his path to recovery is much riskier. Step by step, both parties must reevaluate their risk tolerance based on their new, independent life expectancy and financial goals. The 401k divorce also triggers a need to look at Social Security optimization. In the United States, if a marriage lasted at least 10 years, a divorced spouse may be eligible to claim benefits based on their ex-spouse's earnings record, provided they are not remarried. This does not reduce the participant spouse's benefit. In 2026, as the Social Security Trust Fund discussions dominate the news, understanding how your 401k balance interacts with your future Social Security strategy is vital. If you have a smaller 401k balance after the split, you might need to delay your Social Security claim to 70 to maximize the monthly payment, using your 401k funds to bridge the gap in the meantime. There is also the often overlooked issue of the 401k beneficiary designation during the post-QDRO phase. Even if the money has been moved to an IRA, the new account needs a beneficiary. Many people are so exhausted by the divorce process that they leave the beneficiary line blank or, in a moment of confusion, accidentally list their estate. Listing an estate as a beneficiary of a retirement account in 2026 is a significant error. It can force the entire account to be liquidated within 5 years after death, stripping away decades of potential tax-deferred growth for heirs. As we conclude this part of the masterclass, we have to recognize that the 401k divorce is a transition from a shared past to a fragmented future. The tax rules and contribution limits are the boundaries of the playground, but how you play the game determines if you will ever be able to stop working. But what if the 401k isn't the biggest asset? What if there's a traditional pension hiding in the background? Many modern workers have a frozen pension from an old job they've forgotten about, or a cash balance plan they don't understand. How do you value a monthly check that doesn't start for 20 years? And how do you split a pension without accidentally killing the benefit for everyone involved? In the next part, we are going to dive into the world of defined benefit plans and the actuarial math that makes them the most dangerous asset in an American divorce. While the 401k is a transparent bucket of money with a clear daily balance, the defined benefit plan, or traditional pension, is an entirely different beast. In 2026, many American workers, especially those in government, education, or legacy industrial sectors, still hold these powerful yet opaque assets. In a divorce, a pension is not just a bank account, it is a promise of a future income stream. Because you cannot simply log in and see a cash value for a pension, it becomes the most dangerous asset in the marital estate. To divide it fairly, you have to move beyond simple arithmetic and enter the world of actuarial science and present value calculations. Imagine a character named Sarah. Sarah is 50 years old in 2026 and has worked as a public school teacher for 25 years. She is entitled to a pension that will pay her $4,000 a month for life, starting at age 60. Her husband, David, wants half of that asset. But what is half of a $4,000 monthly check that won't start for another decade? This is where the actuarial valuation comes in. An actuary must look at Sarah's life expectancy, the current 2026 discount rates, and the plan's specific rules to determine what that future income stream is worth in today's dollars. In a high-interest rate environment like the one we are seeing in 2026, the present value of a pension might actually be lower than it was 5 years ago, because money today is theoretically worth more. If an actuary determines that Sarah's pension is worth $700,000 today, David might ask for $350,000 from other assets to leave her pension untouched. This brings us to the first major hurdle: the difference between a cash balance plan and a traditional pension. Many modern U.S. employers have shifted to cash balance plans, which look like a 401k but are legally defined benefit plans. These are easier to value because they show a hypothetical account balance. However, a traditional pension requires a step-by-step forensic analysis of the plan's formula. Most follow a variation of years of service multiplied by a percentage multiplied by final average salary. If Sarah and David were married for 20 of her 25 years of service, the court typically uses the coverture fraction, 20 divided by 25, to determine that 80% of the pension is a marital asset. David would then be entitled to half of that 80%. However, the cultural evolution of the U.S. divorce has introduced a critical complication: the survivor benefit. In 2026, a standard QDRO for a pension must address what happens if the employee spouse dies before or after retirement. If Sarah dies at age 55 before she ever collects a dime, and the QDRO doesn't specifically name David as the surviving spouse for the pre-retirement death benefit, David's interest in that pension might vanish instantly. This is a historical trend of catastrophic legal errors. To protect the non-employee spouse, the QDRO must be drafted as a separate interest order, which essentially creates a mini pension for David that is independent of Sarah's life. Let's look at the actuarial math involved in the 2026 landscape. Actuaries are currently using updated mortality tables that reflect the post-pandemic reality of American life expectancy. If David is significantly older than Sarah, the value of his share of the pension is lower because he is statistically likely to collect it for fewer years. Conversely, if he is younger, his share is more valuable. This creates a fascinating negotiation point. In some case studies, a spouse might trade a portion of their 401k for a larger share of a pension because they value the lifetime security over immediate liquidity. But there is a hidden trap: the cost of living adjustment, or COLA. In 2026, with inflation being a primary concern, a pension with a COLA is worth significantly more than one without it. If David accepts a flat monthly payment that doesn't grow, his purchasing power will be decimated over 20 years of retirement. Furthermore, we have to talk about the early retirement subsidy. Some pensions allow workers to retire at age 55 with full benefits if they have 30 years of service. This subsidy can add hundreds of thousands of dollars to the present value of the plan. If Sarah's attorney doesn't account for the possibility of her taking an early retirement, they might be undervaluing the asset by 40%. In 2026, matrimonial experts use what is called the Gilmore rights in some jurisdictions, which allow a non-employee spouse to start receiving their share of the pension the moment the employee is eligible to retire, even if the employee chooses to keep working. Imagine Sarah wanting to teach until 65, but David forcing the plan to start paying him his share at age 55 because she is eligible. This can create a massive financial strain on the employee spouse. The complexity intensifies when we look at government-specific plans like the FERS, Federal Employees Retirement System, or the military's High-3 system. These plans have their own specific federal forms and rules that differ from the private sector's ERISA-governed 401ks. For example, in 2026, Military Pension Division is governed by the Frozen Benefit Rule, which mandates that the non-military spouse's share is based on the rank and pay grade at the time of the divorce, not the time of retirement. If David is a captain when they divorce but retires as a colonel, Sarah doesn't get a piece of that promotion. This is a direct response to a cultural shift where the military argued that post-divorce promotions are the result of individual effort, not the marital partnership. Step by step, the valuation of these plans requires 3 key documents: the most recent benefit statement, the summary plan description, and a complete salary history. Without these, you are guessing. In 2026, we see a trend of people using online pension calculators to estimate value. But these are often dangerously inaccurate because they don't account for the plan's specific vesting schedules or the current year's IRS Section 417E segment rates, which are used to calculate lump sum values. There is also the factor of the anti-alienation clause. Pensions are generally protected from creditors, but a QDRO is one of the few things that can pierce that shield. However, if Sarah has a non-qualified pension, often called a top hat plan for executives, a standard QDRO won't work. These plans are not protected by ERISA, and if the company goes bankrupt in 2026, David's share of that executive pension could disappear along with the company. This makes the 401k, which is held in a separate trust, a much safer asset than a non-qualified pension. As we wrap up this deep dive into the dangerous world of pensions, we have to look toward the ultimate endgame. You've divided the 401k, you've valued the pension, and you've navigated the tax minefield. But there is one more asset that is often the largest of all. Yet it isn't found in any bank statement. It is the Social Security benefit. In 2026, as the laws around Social Security are being debated in Congress, the interaction between your 401k split and your future Social Security check is the final piece of the puzzle. What happens if you were married for 9 years and 11 months? And how does a 401k withdrawal in 2026 affect the taxes you will pay on your Social Security in 2036? In the next part, we are going to break down the 10-year rule and the strategic timing of a divorce filing that can save you $300,000 in lifetime benefits. The concept of the 10-year rule is perhaps the most significant cliff in the American financial landscape, yet it remains buried in the fine print of Social Security Administration guidelines. As we navigate the complexities of 2026, The timing of a divorce filing is no longer just an emotional decision. It has become a high-stakes actuarial calculation. In the United States, if a marriage lasts at least 10 consecutive years, a divorced spouse is generally eligible to receive Social Security benefits based on their ex-spouse's earnings record, provided they meet certain criteria. This is a critical historical trend that provides a safety net for lower-earning spouses. But the difference between 9 years and 11 months versus 10 full years can be worth hundreds of thousands of dollars in lifetime inflation-adjusted income. Imagine a character named Linda. It is May 2026, and Linda has been married to her husband, James, for 9 years and 8 months. James has been a high earner in the medical field for decades, while Linda took a 10-year hiatus from the workforce to manage their household and children. If they finalize their divorce next month, Linda will be limited to claiming benefits based solely on her own truncated work history. However, if Linda and James remain legally married for just 4 more months, reaching that 10-year milestone, Linda gains the ability to claim up to 50% of James's full retirement age benefit amount once she reaches her own retirement age, as long as she remains unmarried. This benefit does not come out of James's pocket. It does not reduce James's own Social Security check, nor does it affect the benefits of any future spouse James might marry. It is a secondary benefit provided by the federal government to recognize the economic partnership of a long-term marriage. In 2026, with the average Social Security benefit for a high earner reaching significant monthly totals, the present value of this claimable benefit can be staggering. If James's benefit at full retirement age is $4,000 per month, Linda's spousal benefit could be $2,000 per month. Over a 25-year retirement, that is $600,000 in potential income that disappears if the divorce decree is signed even one day before the 10th anniversary. The step-by-step strategic timing of a divorce in 2026 requires a cold analytical look at the calendar. Family law attorneys often see clients who are in a rush to just be done with it. But failing to wait those extra few months is often cited in legal malpractice case studies as a failure of fiduciary duty. To qualify, the marriage must have ended in a final divorce decree. The marriage must have lasted 10 years. The person claiming must be at least 62 years old, and they must be currently unmarried. If Linda remarries, she generally loses the right to claim on James's record, unless that subsequent marriage also ends by death or divorce. But how does this interact with the 401k division we have been discussing? This is where the cultural evolution of the offset comes into play. In 2026, a savvy negotiator might realize that because Linda will eventually have access to this Social Security stream, James might argue that he should keep a larger portion of the 401k to balance the future scales. However, the law is very specific. Social Security benefits are federal entitlements and are not subject to division by state courts in the same way a 401k is. James cannot buy out Linda's right to his Social Security record, nor can a judge order her to waive it. It is an independent right granted by federal statute. Let's look at the data regarding the divorce survivor benefit. This is the darker, more protective side of the 10-year rule. If James were to pass away after they have been divorced for many years, but they were married for at least 10 years, Linda can claim 100% of his benefit amount as a survivor, rather than just the 50% spousal amount. In a world where 401k balances can be exhausted by market crashes or poor spending choices, this guaranteed, government-backed survivor benefit is the ultimate insurance policy. For a spouse who has had their 401k halved in a 2026 divorce settlement, this survivor benefit often becomes the difference between poverty and a dignified old age. Another layer of this evolution involves the independently entitled rule. In the past, a divorced spouse had to wait for their ex-spouse to actually file for Social Security before they could claim the spousal share. In 2026, as long as the divorce has been final for at least 2 years and both parties are 62 or older, the claiming spouse can trigger their benefits regardless of whether the ex-spouse has started theirs. This prevents an ex-spouse from using the timing of their retirement as a weapon of financial control. The 2026 landscape also forces us to look at the windfall elimination provision, or WEP. If one spouse, like Sarah from our previous case study, worked in a job where they didn't pay into Social Security, such as certain teaching or government positions, but the other spouse did, the amount of the spousal benefit could be drastically reduced. This is a common pitfall in American divorce math. If Linda assumes she will get $2,000 from James's record, but she has her own small pension from a non-covered government job, the government may offset her Social Security benefit, potentially reducing it to nearly zero. This is why a deep dive masterclass requires looking at the Social Security statement and the pension summary simultaneously. You cannot view one in a vacuum. Historical trends show that as the 401k became the primary vehicle for American wealth, the reliance on Social Security as a floor increased. When you split a 401k, you are splitting the upside and the risk. When you secure a 10-year marriage Social Security right, you are securing a floor. In 2026, the strategic use of the separation agreement versus the final decree is a common tactic. A couple might decide to separate emotionally and physically today, but agree not to finalize the legal divorce until the 10-year clock has officially run out. This requires a high level of cooperation and trust, which is often in short supply during a split, but the financial data makes a compelling case for a truce until the anniversary passes. Imagine the complexity if James has been married multiple times. In 2026, it is entirely possible for 3 different ex-wives to all claim Social Security benefits on James's single earnings record, provided each marriage lasted 10 years and James earned enough credits. None of these claims reduce James's check, and none of the ex-wives' claims reduce the others. This is a unique quirk of the U.S. system that highlights the cultural evolution of the family unit, from a single-earner household to a series of successive economic partnerships. As we move toward the final stages of our masterclass, we have to address the reconstruction phase. You have timed the divorce to maximize Social Security, you have utilized a QDRO to split the 401k without penalties, and you have valued the pension. But now, you are standing alone in 2026 with exactly half of what you thought you would have. The new normal requires a complete overhaul of your estate planning. If you don't update your will, your power of attorney, and your healthcare directives the moment the divorce is final, you are leaving your 401k and your life in the hands of the very person you just spent years legally untangling yourself from. What is the 7-day window that can invalidate your new beneficiary choices? And how can a revocation by divorce statute in your state actually work against you if you want your ex-spouse to remain as a trustee for your children? In the next part, we are going to look at the post-divorce legal cleanup and the estate planning trap that catches 40% of Americans within the first year of being single. The ink on the divorce decree is dry, and the 401k funds have finally been moved into your separate account. You might believe the battle is over, but in 2026, many Americans fall into the estate planning trap, a period of legal vulnerability that can undo years of careful negotiation. The cultural evolution of American domestic law has created a phenomenon where the court-ordered division of assets is often at odds with your standing estate documents. If you do not perform a comprehensive legal cleanup within the first few months of your new life, you are essentially leaving your financial legacy in a state of suspended animation. Imagine a character named Kevin. It is August 2026, and Kevin has just finalized a high-conflict divorce. He successfully petitioned his $700,000 401k, keeping $400,000 in a new rollover IRA. He feels secure. However, Kevin forgets one critical step: updating his last will and testament in his 401k beneficiary forms. 2 months later, Kevin is involved in a serious accident. Because he never updated his documents, his ex-wife is still listed as his primary beneficiary and his power of attorney. Despite the fact that they just spent 2 years fighting in court, the law in many jurisdictions may still default to those written designations unless specific, step-by-step actions were taken to revoke them. This brings us to the first major hurdle of 2026, the revocation by divorce statutes. Most states in the U.S. have laws that automatically revoke a former spouse's status as a beneficiary upon the finalization of a divorce. However, these statutes are not universal, and they are frequently preempted by federal law. If Kevin's 401k is still held within his employer's plan, governed by ERISA, federal law often dictates that the plan administrator must pay the person listed on the form, regardless of state law or the divorce decree. This is known as the plan document rule. In the eyes of the Supreme Court, the administrative ease of following a form outweighs the equitable arguments of a divorce decree. If Kevin dies before moving that money to an IRA or updating the form, his ex-spouse receives the $400,000, and his children or new partner may have no legal recourse. To avoid this, you must follow a post-divorce blueprint for asset protection. Step 1 is the immediate update of all beneficiary designations. This includes not just your 401k and IRA, but also your life insurance policies, health savings accounts, and even transfer-on-death bank accounts. In 2026, the speed of digital finance means these transfers can happen in hours. If you wait until the next tax season to look at your paperwork, you are living in a zone of high risk. Historical trends show that 40% of divorced individuals fail to update these forms within the first 12 months, often leading to protracted litigation between ex-spouses and surviving family members. Step 2 involves the 7-day window. This is a concept often discussed by estate attorneys regarding the gap between the signing of a divorce decree and the actual update of legal documents. During this window, you are in a legal gray area. If you want your children to be the beneficiaries of your newly divided 401k, you cannot simply rely on the fact that you are divorced. You must proactively name them. However, if your children are minors, you cannot simply list their names. In 2026, the IRS and financial institutions are very strict about moving large sums of money to individuals under the age of 18 or 21. If you name a minor directly, the court may appoint a guardian ad litem to manage the funds, which involves more fees and court oversight. The sophisticated move in 2026 is to create a revocable living trust and name the trust as the beneficiary of the 401k, with specific instructions on how the money should be distributed for the children's education and health. Step 3 is the reevaluation of your power of attorney and healthcare proxy. This is perhaps the most emotionally charged part of the post-divorce cleanup. If you are incapacitated in 2026, who do you want making decisions about your medical care or your remaining 401k assets? If your ex-spouse is still listed on your durable power of attorney, they could technically still access your accounts or make life-ending medical decisions. In a post-divorce cultural landscape, the trust that once existed is often gone. Yet many people leave these documents in place because they are too exhausted to revisit the lawyer's office. Case studies show that failure to update healthcare proxies can lead to hospital room standoffs between ex-spouses and biological parents, all while the patient is unable to speak for themselves. We also have to look at the tax implications of these new estate structures. In 2026, the Secure Act 2.0 has made it so that most non-spouse beneficiaries of a 401k or IRA must withdraw all the funds within 10 years. This is the 10-year rule for inherited IRAs. If you leave your 401k to your siblings or your adult children, they will face a massive tax burden over that decade. However, if you are newly single, you no longer have the marital deduction for estate taxes. This means your estate may be subject to federal and state estate taxes at a lower threshold than when you were married. Step by step, you must work with a tax professional to ensure that your 401k is positioned to provide the most value to your heirs with the least amount of tax friction. Another layer of the 2026 evolution is the rise of the digital estate. Your 401k login, your cryptocurrency keys, and your digital footprints are all part of your wealth. In a divorce, these are often split, but the security protocols are rarely updated. If your ex-spouse still has the password to your financial aggregator app, they can see your real-time balance and your spending habits long after the QDRO is processed. This is not just a privacy issue. It is a security risk. A comprehensive cleanup requires a total digital reset, new passwords, two-factor authentication tied to a new phone number, and a removal of all shared access to financial cloud storage. Imagine the complication if you decide to remarry quickly. In the US, many states have laws that give a current spouse an automatic right to a portion of your estate, including your 401k, regardless of what your will says. If Kevin marries a new partner in late 2026 but still hasn't updated his 401k beneficiary from his first wife, he has created a three-way legal battle between his first wife, his new wife, and the law. This is why a prenuptial agreement for a second marriage is often considered an essential part of the post-divorce recovery process. It allows you to protect the 401k you fought so hard for, ensuring it goes to your children rather than being split again in a potential second divorce. The cultural evolution of the 401k divorce has taught us that the finish line is further away than it looks. The division of the asset is the climax, but the estate planning cleanup is the resolution. Without it, the story remains unfinished and the ending is outside of your control. We have spent this masterclass looking at the math, the taxes, and the legal strategies of the split. But there is one final piece of the puzzle that almost no one prepares for: the psychological and financial rebuilding of your 401k from 0 or 50% to a level that allows for a genuine retirement. How do you accelerate your savings in your 40s or 50s without falling into high-risk traps? And what are the historical trends of those who successfully retired after a late-life divorce? In our final part, we are going to look at the rebuilding blueprint and the exact investment strategies that 2026 high achievers are using to reclaim their financial independence. The psychological weight of seeing a retirement account balance sliced in half is often the most significant barrier to financial recovery in 2026. After months or years of legal friction, the natural impulse is either to stop looking at the numbers entirely or to swing toward extreme risk in a desperate attempt to recover lost ground. However, the cultural evolution of the American 401k divorce has led to the development of a specific rebuilding blueprint utilized by high achievers to reclaim their trajectory. This is not about overnight success. It is about the clinical application of tax-advantaged strategies, aggressive contribution restructuring, and the mathematical reality of time-weighted returns in the post-divorce era. Imagine a character named Elena. It is late 2026, and Elena is 51 years old. Following her divorce, her 401k balance was reduced from $800,000 to $400,000. In her previous marital life, she was contributing 10% of her salary. Now, standing alone, the math of her retirement has fundamentally shifted. To reach her original goal of $2 million by age 65, she cannot simply continue what she was doing before. She needs a step-by-step tactical overhaul of her cash flow. The first pillar of the rebuilding blueprint is the maximization of the catch-up contribution. In 2026, the IRS allows individuals aged 50 and older to contribute an additional $7,500 to their 401k beyond the standard limit. For Elena, this means she can funnel $30,500 annually into her 401k. By automating this at the payroll level, she reduces her taxable income, which is crucial now that she is likely filing as single or head of household, categories that often carry higher tax rates than married filing jointly. Historical trends suggest that many individuals fail to trigger this catch-up provision because they are overwhelmed by the immediate costs of their new lifestyle. But in 2026, every dollar contributed in your 50s has a disproportionate impact on the final outcome due to the compression of time. The second pillar involves the Health Savings Account, or HSA, which many in the U.S. call the Stealth IRA. In 2026, high achievers are using HSAs as a secondary retirement vehicle. If Elena has a high-deductible health plan, she can contribute to an HSA, receive an immediate tax deduction, let the money grow tax-free through investments, and withdraw it tax-free for medical expenses. More importantly, after age 65, she can withdraw the money for any purpose, paying only ordinary income tax, effectively making it a backup for 401k with no early withdrawal penalties for health costs. For someone who just lost half their retirement, the triple tax advantage of the HSA is a critical tool for rapid capital accumulation. Let us look at a case study of aggressive rebuilding through the mega backdoor Roth. Imagine if Elena's employer allows for after-tax contributions and in-service distributions. In 2026, the total contribution limit for a 401k, including employee deferrals, employer matches, and after-tax contributions, is significantly higher than the individual deferral limit. Elena could potentially put away an additional $30,000 to $40,000 into the after-tax portion of her plan and immediately convert it to a Roth 401k. This allows her to build a massive tax-free bucket of wealth in her 50s. While she can no longer rely on her ex-spouse's contributions, she is utilizing the full capacity of the tax code to protect her future income from the IRS. Pillar 3 is the total reassessment of investment risk. In 2026, the traditional 60-40 stock-to-bond ratio is being questioned by many financial analysts, especially for those who have suffered a significant asset split. Elena might feel the urge to put all $400,000 into aggressive growth tech stocks to catch up. However, the rebuilding blueprint suggests a more nuanced approach. Since she is now an individual economic unit, she has no second income to buffer a market crash. Step by step, she must align her portfolio with her actual date of retirement. This often involves a barbell strategy, keeping enough in highly liquid, low-risk assets to cover 3 years of living expenses, while keeping the remainder in diversified equities to capture market growth. We also have to discuss the cultural evolution of the side hustle as a retirement accelerator. In 2026, many professionals in the U.S. are using 1099 consulting work alongside their W-2 jobs to open a solo 401k. If Elena consults on the weekends, she can contribute a significant portion of that side income into a solo 401k, essentially doubling her ability to save. This is a historical trend among the silver divorce demographic. using the newfound autonomy of single life to increase income and aggressively fund retirement accounts that were depleted during the marriage. But the blueprint isn't just about contributing more. It is about spending less on the friction of life. In 2026, the cost of housing is the largest expense for the newly single. Elena might decide to downsize her home immediately to free up an additional $2,000 a month. That $2,000, if invested into a diversified index fund inside her 401k, can significantly alter her potential outcomes over the next 15 years. The math is relentless. A 51-year-old who saves an extra $24,000 a year for 15 years at a 7% return could see an additional $600,000 in their nest egg. This is how the gap created by a divorce is bridged. Another layer of the 2026 recovery is the strategic use of the 401k loan, but in reverse. Many people use loans to pay for the divorce, but the high achiever uses the settlement to pay off any existing 401k loans immediately. This restores the principal and allows the full balance to participate in market rallies. Furthermore, in 2026, we see a rise in the use of professional investment fiduciaries who specialize in post-divorce wealth management. These experts help avoid the emotional trading that often sabotages a recovery. They provide the clinical distance needed to view the 401k as a math problem rather than a reminder of a failed relationship. The final component of the rebuilding blueprint is the long-term tax strategy. By the time Elena reaches 65, she will likely have a mix of traditional 401k funds, Roth funds, and HSA funds. In 2026, the most successful retirees are those who understand the order of withdrawals. By taking money from the right buckets at the right time, they can stay in a lower tax bracket and preserve their capital for longer. This is the ultimate victory in a 401k divorce. Not just getting half of the money, but managing that half so effectively that your standard of living in retirement remains unchanged. As we conclude this deep dive masterclass, it is clear that the 401k divorce is one of the most complex financial events in a modern American life. It is a collision of federal tax law, state domestic relations, and individual psychology. We have covered the history, the QDRO mechanics, the tax traps, the pension valuations, and the estate planning cleanup. But information is only as good as the action that follows it. The cultural evolution of the U.S. retirement landscape means that you are now the primary architect of your own security. You have the blueprint. You understand the math. But the 2026 economy is always moving. What happens when the next major shift in Social Security law occurs? And how will it affect the 401k contribution limits for the next decade? The journey of financial independence never truly ends. It simply changes shape as you move from one phase of life to the next. Stay tuned for our next series where we break down the emerging 2027 tax codes and how they will redefine wealth for the next generation of American workers.